your understanding. My notes from last time were essentially that you two seemed to be close to an agreement on a parenting plan after you both agreed there was adequate cause to issue a new one. But without him here today, what can you tell me?
Nothing.
Okay.
We haven't. I've gotten a hold of him twice about filling out the parenting plan, this new one, to agree on something. The first time was a couple days after our last court date, and I said, "Hey, when are you available?" And he goes, "Oh, I'm available whenever." I said, "Well, do you just want to come over real quick?" Because I had already printed up the paper. He goes, "Oh no, I can't come right now." And I talked to him a couple weeks later and mentioned it. And I said, "Hey, this is my availability." Haven't heard from him. He's seen Dustin once. Um, I don't want to, I'm not trying to badmouth, but honestly, like, it's kind of why we've been sitting in the same spot for
Yeah.
4 years because I'm not going to force it. I don't want to force it. I'm not going to make.
Let's do this. Here's going to be my proposal because we talked about this last time.
Hmm.
And what I talked about last time was if you two didn't come today with an agreement, then my inclination was to send you all to mediation. Are you still open to that? I think my inclination is to go ahead and sign that order and get you all set over to mediation.
I mean, I'm open to anything I want him to be in Dustin's life, but I mean, he's almost 12 years old and we're still sitting. I don't know. I want it to be genuine. I want him to want it.
So the other option is if you want to prepare your proposed parenting plan and serve it on Mr. Smith, and then we'll schedule a date. You have to have 21 days service before a hearing,
Yeah.
so I'd probably put it out 30 days.
Okay.
And then you can come request whatever you want, and I can make the decision. If Mr. Smith appears, Mr. Smith appears, and if he chooses not to participate, that's up to him. Do you have a preference on how you would like to proceed?
I don't even really know what to bring to the courts like for I don't even know what I would propose in a parenting plan. I don't even know what I would put in there. I don't
So
we
we have, and I always ask this question. I apologize to the clerks. What is the day we have the legal aid here?
Mondays from 12 to 2.
12 to 2. Thank you. You would think I would remember that by now. Okay. So one of your options, Ms. Fleischman, every Monday between 12 and 2, we do have family law lawyers that are available here in the courthouse for you to come talk to for free legal advice. So
oh,
they could give you some starting points for getting a proposed parenting plan together.
I see. Am I able to ask Dustin what he would like this to look like? Like, am I allowed to involve him in this?
Yes. Uh, I wouldn't say often, but sometimes people do present me with agreed orders, or let's say orders where you guys agree on 80% of the things, and then you come to me for the 3 things you don't agree on, and I make a ruling. So absolutely, you can work collaboratively with him. That's also the benefit of mediation. If I send you all to mediation, the two of you sit down with a mediator to work through what a parenting plan could look like.
I understand that. I was meaning, can I get Dustin, the child, and can I like?
Oh, I thought you said Nathan. I
I'm
apologize.
I'm sorry
You know, my there's no
because he. Oh, I'm sorry.
here's what I would say. As a judicial officer, I don't like to include kids in the adult decisions of parenting and parenting plans. What I would say though is you are his mom, and if you want to ask him what he is comfortable with, that's certainly up to you.
That's what it would be.
But typically we say, keep the kids out of it. But I think for me, that means, I wouldn't want him reviewing paperwork with you.
Oh, no, no, no,
Like
no.
that.
It would be
Yeah.
more of like, because I'll tell him like, why don't you call your dad? He was like, he don't call me. I'm not gonna, and I don't want him to have. I understand why he thinks that, and he was, I don't know. He doesn't really want to visit.
Well,
He's stressed some things to me about when he has gone to his house. He feels that, Nathan is a little, he talks, he's like, Mom, I don't know how to explain it. He just talks a little weird.
So let's do this. So I'm not hearing a ton of facts about the case without Mr. Smith present. I'm going to give you the option today. I can either sign the mediation order and we can see if Mr. Smith shows up and participates in mediation, or we could set you at about 30 days. That would give you time to meet with legal aid to formulate whatever parenting plan you are proposing, and then I can review that after you serve it on Mr. Smith.
Let's do that.
I'd rather do that. Okay.
Yeah.
So just, I'll set you out 30 days to, let's do December 27 at 9 a.m. Just know that means you have to serve Mr. Smith your proposed parenting plan 21 days before that.
Okay.
So if you haven't finished that parenting plan this week and gotten it to Mr. Smith, then contact the clerk so we can change your hearing date.
Okay. So it needs to be, you said 21 days?
21 days before December 27th.
Okay.
Okay. So we'll get you put on December 27, 9 a.m. unless we hear otherwise from you. And then again, remember, Mondays 12 to 2.
Yes.
Come to the courthouse. They can help you out with the start of some ideas. Okay.
And you said it didn't cost anything?
Correct.
Okay, perfect.
Okay. All right. Thank you. All right.
The last times I've had my cameras on, it interferes with being able to hear me. So that's why I have it off.
Okay. That's okay. That does preserve some bandwidth. No problem. Ms. Johnson, you are muted, so you'll need to unmute. If you're on a phone, it is *6. So when we were here last, I did take a look at this file, and my understanding is that Mr. Lawrence has done quite extensive review of this case, interviews, talked to parties and collateral sources, and he has issued a report with recommendations regarding a parenting plan. Have you both received that, or are you aware of the recommendation?
Yeah, I got it in my email.
Okay.
Yes, I received it as well.
Okay. Are the two of you in agreement with those recommendations, or are you disputing a parenting plan being entered with those recommendations?
I don't have an issue with them, no.
Mr. Perkins?
I don't fully agree with the parenting plan that he's presented.
You do not agree with the parenting plan he's proposing?
No.
Okay. What are your points of disagreement, and then I'll figure out what we need to do with this case to resolve those.
Okay.
Sorry, it's hard for me to hear. My main point of disagreement, or my main point of disagreement is the week on, week off shuffling of Clayton between myself and his mother, and the 50-50 decision making.
Okay. So I'm just looking here real quick. Do we have a temporary? Did you all ever have a temporary parenting plan in place?
We never had one officially filed with the courts. We've had a few mutual ones that we have been working off of, depending on Tanya's location of residence.
Right. And I see that. So I just want to make sure I wasn't wrong on, I didn't see a temporary parenting plan even going all the way back to January. I didn't see that there was ever a temporary parenting plan signed by a judge. There were different proposals throughout time, but nothing actually ever approved. Does that meet with everyone's recollection?
Yeah.
Yes.
So then what I'm inclined to do today is essentially today will be a short hearing on what a temporary parenting plan will look like. I will make a decision about that today after some short testimony. And then you all obviously, the end result is a final parenting plan. A final parenting plan, Mr. Perkins would be we would enter a temporary parenting plan. A lot of times the court reserves ruling on certain issues in a temporary parenting plan. And then we set forward dates that can include a contested fact finding or trial day for either party. So I think that's my preference today. Mr. Lawrence, I just want to make sure you didn't see any temporary parenting plan already in place, did you?
Your Honor, I believe there was an entry in Odyssey on August the 2nd. That was entitled
yeah, Ms. Johnson, I'm going to need you to mute. I can't hear. Go ahead, Mr. Lawrence.
On August the 2nd of 23, there was an entry in Odyssey that was entitled Temporary Parenting Plan, but I believe the parties are actually correct that there really never was.
Yeah, it was a little confusing to me because it got noted on for a motion docket to change the parenting plan. Oh, sorry. I'm looking in the wrong spot. Hold on. Okay. That makes a lot of sense. So it does sound like it was docketed. The note for motion docket was for approval of a temporary parenting plan. And I'm just looking at the clerk's notes from 10:25 a.m. that day at the hearing where I was the judicial officer and indicated I was unable to sign the proposed orders. So I think that does take us back to we are in a position to discuss a temporary parenting plan today. I will make a ruling on that. And then the parties obviously are free to note for trial or whatever they decide to do as we go forward for a permanent parenting plan. So what I'd like to do first is hear from Mr. Lawrence. I have reviewed your recommendations. Thank you. It was a very in-depth report. Very much appreciate it. Essentially the basis for your recommendations. And then Mr. Perkins as petitioner, I'll go to you next. And then Ms. Johnson as respondent, I'll go to you next. So go ahead, Mr. Lawrence.
Well, Your Honor, at the time of separation, Tanya had Clayton, and she was suffering from depression. And Mr. Perkins filed for a parenting plan back in January of this year. And in that parenting plan, he had recommended that there be a 50-50 arrangement. And so he was satisfied with Ms. Johnson's ability to parent. Mr. Perkins was concerned about her mental health issues, but Ms. Johnson also had issues about Mr. Perkins being verbally and emotionally abusive. So when after he had filed his parenting plan, the initial one, Tanya came to Mr. Perkins and indicated to him that for the betterment of Clayton, her depression was not under control, and that she felt that it would be better if he had the majority of the time with Clayton. However, what's happened since is that she's had her medication reviewed, and she now is under medication that has stabilized her, and she no longer feels that she has any issues with being able to parent Clayton. However, Mr. Perkins is continuing to share concerns about her mental health. He also has expressed concerns about her husband. but he never has ever stated any specific evidence that he has that would back up his claims of being concerned about these folks. My review showed that Tanya Johnson has stabilized, and that I could not find any deficits really that would preclude her from having significant contact with Clayton. Mr. Johnson, her current husband, is a truck driver. He has quite a few traffic tickets related to his work, but he only had a couple of criminal charges that go back a number of years and nothing new, and there were no sex offenses or anything like that. So there was no indication that there was a concern about his criminal history. I spoke to Tanya's mother. Tanya's mother in 2009 had reported Tanya to CPS as a result of Tanya's then boyfriend having inappropriate contact with her older daughter. There was never any issue with Clayton at that point because Clayton wasn't even born. That investigation apparently went nowhere because the result was it was unfounded. So we have a lot of allegations on Mr. Perkins' part, but I'm not finding any evidence to support anything that would preclude Ms. Johnson from being an active parent with her child. I am concerned that the more time that Ms. Johnson misses with Clayton, that his ability to bond with her is also suffering. She moved to Texas, as the court is aware, a few months back. She was down there. She made at least one visit where she came back to Washington to meet with Clayton. That went well. And the visits were very cumbersome. And Miss Johnson and her husband decided that they would return to Washington. And they did so here about a month ago. And they're living with Mr. Johnson's parents currently, and they're in the process of trying to find a home for themselves where they can take care of Clayton as well. As Clayton is only 2, he's got at least 3 years before he goes to school. Mr. Perkins lives in Wilsonville, Oregon, but is thinking of moving back to the Vancouver area. So it made a lot of sense to me that unless there's some evidence to the contrary, that Ms. Johnson have as much time with Clayton as Mr. Perkins does, and that this should be a suitable arrangement.
I appreciate that. Okay, Mr. Perkins, I'm going to come to you next. So essentially what we're looking at is, for purposes of temporary orders, what a parenting plan looks like. You have reviewed the GAL recommendations. What is your request of this court regarding a temporary parenting plan?
Well, with regards to a temporary parenting plan, I would be on board with the week on, week off to see how things go. As I've expressed to Mr. Lawrence previously and have continually expressed to the court, my concern has been with Tanya's decision making and just her overall life stability. From the get-go, I started with the 50-50. I was working with a lawyer. I was told that that was the best that I could hope to get, and with regards to that, so that was the advice I was taking from my lawyer, which is why I went with that plan. And then everything didn't work out with that plan, and then the issues continue with Tanya changing her mind on what she wanted to do with the parenting plan as she worked on her mental health. So, but from that first plan forward, I've had the same position every time, and I've been the one that has initiated all requirements as to getting a parenting plan, trying to get proposed time between Clayton and I have not received equal participation from Tanya on that. So I guess my overall concern is, or my view is, if she's so worried about her bonding with Clayton, why has all of her decisions up to this point been to not put action with those words?
Anything else you want the court to know?
I mean, with regards to where my position comes from, I had stated to Mr. Lawrence that she has a 16-year-old daughter that was in her care, that was removed from her care and had guardianship placed with another family member here this year due to Tanya's instability in her life and the fact that her daughter didn't feel safe or comfortable being around her current husband. But I don't see any of that in his report. I mean, it's on file with Clark County Court. So,
anything else, Mr. Perkins?
no, that's it at this time.
Okay. All right. Ms. Johnson, what would you like the court to know regarding a formulation of a temporary parenting plan?
I have no problems with the temporary plan. As far as some of the stuff that I'm being accused of, my daughter, she chose to leave my home. It wasn't because of anything that I was doing. There was no reason for her to be afraid of my husband. That was something she chose. She's a 16-year-old child with some mental health issues herself. My husband was very kind to her, tried taking her out to lunch, trying to make her feel comfortable with him. There was no reason for her to feel unsafe with him. My son, I feel I gave him to James more often because I felt my mental health was an issue, because I was causing him stress, because he was causing me stress, because my depression was pretty low at the time because of all the stuff that was happening between James and I. And when I'm stressed, Clayton feels it. So he was causing me a little more stress. I was stressed, and it was just a vicious cycle. So I chose to step away from Clayton as much as possible without severing that tie. I chose to put Clayton in James's care to make it so Clayton was safer and didn't have that stress. I'm in a much better place. I don't get stressed out anymore. The medication that I'm on is helping me a lot. I feel that my bond with Clayton has deteriorated some since all of this has been going down. I'm here back in Washington. I'm not going anywhere. I want my bond back with my son. I feel that Mr. Perkins's relationship with Clayton isn't the greatest because he works he's at work all day long and only spends a couple hours with him maybe at night and on the weekends. He spends all day with his aunt because she's the child care person. And he's starting to call me auntie because that's who he is with all day long. So I feel the longer he is out of my care, the less bond I will have with him. So I'm good with the 50-50 week on, week off, because I need that time with him again.
Okay. Mr. Lawrence, any other input based on what you've heard from the parties?
No, I've heard these statements from both of them in the past, and I stand by my recommendation.
Thank you. I appreciate that. What I'm going to do is sign a temporary parenting plan and family law order. I'll have to craft it after docket today, since there isn't a proposal right now in front of me that mirrors what my ruling will be. First of all, just based on Mr. Perkins' initial request to this court, I'm going to reserve on any findings that would be 3A or 3B limitations. At this time, I don't find that abandonment, neglect, lack of emotional ties, etc. apply. So I'm not going to enter any of those findings. I am going to adopt the GAL recommendations that includes the 1 week on, 1 week off visitation schedule with Clayton. The exchanges will be made on Sundays at 6 p.m. to occur at the receiving party's home. The parent who is bringing the child back. So the parent who has had that week with the child will be the one to bring them to the other parent's home Sunday at 6 p.m. I don't find any reason to limit decision making at this time for purposes of the temporary order. So education and healthcare will be joint decision making. I am going to order that both parents complete a parenting class. The two recommendations that Mr. Lawrence included were Love and Logic or Children in Between. I think both of those are great recommendations. Either is fine with the court. The summer schedule, given the child's age at this time, will remain the same, which will be 1 week on, 1 week off. Mr. Lawrence did include school age recommendations. What I'm going to indicate is we'll reserve school schedule for permanent parenting plan since he's 2 at this time. So we'll hold off on putting that in the temporary order for now. The holiday schedule will be the odd, even, alternating schedule. I will put a requirement, Ms. Johnson, that you remain fully compliant with your mental health treatment and medication. How often are you seeing a medical provider right now?
Right now, I'm in between health insurances because my husband just changed jobs since we came back to Washington. So we're waiting for the insurance to go through, but I do have a 90-day supply of my medication.
Okay. What I would like is, do you think will you be able to get back in with a mental health appointment within 60 days?
I'm hoping to, yes.
Okay. I am going to put that in the order. I do very much appreciate your recognition of the cycle of stress and depression and how that could affect your child. I think you made a healthy decision to step back a little bit. So that all shows me really good decision making, even when you are dealing with some mental health issues. I just want to make sure that you maintain that professional support for the best interest of your child. If you run into an issue with getting back into a mental health provider within 60 days, certainly, I'm open to discussing what those roadblocks have been. It's not, I'm not going to find you in contempt over it if it's a health insurance issue, certainly. But it's just my hope that you maintain that professional relationship so that you stay in the good and healthy place that you are for now.
Absolutely, Your Honor.
And then going back to the recommendations, if you both haven't already downloaded Our Family Wizard, it's a great app. I'll put it in the order as a strong recommendation. It's a great app where the two of you can communicate regarding the child's activities and coordination of drop-off and pickup and those sorts of things. I do routinely put in the order, as Mr. Lawrence recommended, that neither party speaks poorly about the other party in front of the child. Also, don't talk about the family law proceedings with a 2-year-old. That obviously does more harm than good at this stage. I don't think either one of you at this time has any child support orders in effect. Is child receiving any sort of state assistance through medical or anything like that, financial or medical benefits?
No, Your Honor. Myself am solely 100% providing Clayton with all his needs financially.
And while I have Clayton, I'm supplying what I need to supply, so.
Okay. Well, when we come at this time, Mr. Perkins, as the petitioner, was not making any requests for support. However, Mr. Perkins, obviously, you can bring a request for this court to enter a child support, or either one of you can bring a request for this court to consider child support orders. So we'll reserve on that issue. I am going to indicate that if there's any disputes with this parenting plan, you can come directly back to court without going to mediation. Obviously, and this is pretty typical for orders I put into place, Mother's Day will always be with Ms. Johnson. Father's Day will always be with Mr. Perkins. I don't typically alter those weekends. So even if it's not technically your week with the child, those holidays should always be with the parent that is being celebrated.
What even odd year would be mine and which would be James's?
Let's start with, if we start this proposal, and where is the child right now?
Right now he's in my care.
Okay.
I just got him on Sunday or Monday.
You got him on Monday. Okay. Is the intent then that he would go back to Mr. Perkins on Sunday?
Yeah, I think so. We never really set a date as when he would go back. We just said a week. So,
okay. Mr. Perkins, was your intent for child to be back with you Sunday?
I was open to either Sunday or Monday. Just kind of give her the full week if she wanted till, since she didn't get him until Monday evening, I would get him Monday evening to make it a even full week, but I can do Sunday as well.
Okay. I'll put Sunday at 6 p.m. just to keep it consistent moving forward. But obviously, if the two of you want to have the exchange be Monday and you work that out, that is absolutely acceptable. No issues there at all.
Thank you.
I think what I'm going to do, let's talk quickly about the Christmas holiday, because that is the next big one coming up, Christmas and New Year's. Do the two of you have a general way that has been done?
He had Clayton for Christmas last year, so I didn't get a choice.
Is there any request? I don't know. Some families, Christmas Eve is more important to them versus Christmas Day.
Well, I would like Clayton this Christmas Day because I didn't get him last Christmas Day. If possible, Your Honor.
Mr. Perkins, what would be your request for this upcoming Christmas holiday?
I'm fine with her having him on Christmas Day. I had him last year at her request, so this would be the alternating year, so that's fine with me.
So then we'll start with you, Ms. Johnson. So this will be the alternating Christmas holiday for you. So we'll start you out there. And then we'll just alternate from there. Is there a request, Mr. Perkins, that you want Christmas Eve, or are you including Christmas break with her to include Christmas Eve with child also?
I would like to have Christmas Eve. I would like it to be, whoever has him for one doesn't have him for the other, just so it's a little more even.
Okay. Yeah. Ms. Johnson, are you okay with Christmas Eve being with Mr. Perkins?
I'm okay with that.
And then we'll have Christmas Day, let's say. Do you want to do exchange Christmas Eve night before bed, or do you want to do it first thing in the morning?
I would like it that evening. That way Clayton can wake up to Santa presents, per se.
What's his normal bedtime?
I think James puts him to bed about 8:30.
That's correct.
Okay.
Somewhere between 8:30 and 9 o'clock is his normal bedtime.
Yeah, okay. I've been trying to do about the same.
Okay. So, and it's Christmas or Christmas Eve. I understand he might stay awake a little longer. So let's say, Mr. Perkins, you return child to Ms. Johnson between 8 and 9 p.m. Christmas Eve.
Okay.
Okay. Anything else you want me to clarify in this temporary order currently?
Just moving forward, is there a planned expiration of the order, or just is there like a limit on how long it goes until we figure out a permanent one, or is it just kind of play it by ear, or how's that work?
Right. So that is up to the parties. Typically what the court would do is put this into place. That gives the parties and the court, we'll set a review date, let's say 2 months out, 3 months out, whatever the parties are comfortable with. We'll see how this temporary parenting plan is going. And then it's up to either the petitioner or the respondent then to file and move for a permanent parenting plan. And that can, if it's going well, that can look identical to the temporary one. If it's not going well for either party, you can request mediation. You would have to go to a mandatory settlement conference at some point, and then trial if there was a dispute between the parties on the permanent plan.
Okay.
So kind of all of the above, a little bit of court review, but ultimately it's up to you all to decide what you independently want to ask the court for permanently.
Okay. Do we need to put in writing today what we want for the review date, or is that something we can talk about?
Yep. No, I will ask for input before you guys log out today. If you want to come back in I would probably not sooner than 60 days. So I would say 60 or 90-day reviews. I don't know if the parties have a preference.
My initial thought was either 3 months or 6 months.
Okay. Let's do 3 months. So how about we put you all February 28, 2024 at 9 a.m. And that'll just be a review hearing. And again, though, if at any time parties want to move for modifications or move this case forward for the permanent order, you are free to note that up independently of the dates I'm setting today.
Okay. And are we going to get copies of the temporary plan?
So I will file it with the court clerk by the end of today. So just reach out to the clerk's office probably tomorrow and they can get you a copy. There usually is a small cost for that. Can't remember off the top of my head, but it's not much. You don't need a certified copy. Just a regular copy will be just fine.
Okay.
The review date, you said that was the 28th at 8 a.m. or 9 a.m.?
9 a.m. If I said 8 a.m., spoke, it is 9 a.m.
Okay.
Okay.
Alrighty. And then the request for the orders that you're signing today, does that have to be in person, or can it be mailed, emailed, or is there a preference?
Let me ask, do they need to come in person for copies?
They can pick it up or they can do a record request from the clerk's website.
Oh, okay. So I learned something new today. You can, if you're not able to come in person or don't have the time to, you can do a records request. There's a link on the Cowlitz County Superior Court clerk's website to do that records request, and you can do it that way, and then it gets mailed to you.
Your Honor,
okay.
Yes.
Once it's entered into Odyssey, I could download it and email it to the parties if that's acceptable.
Oh, that works just fine for me. That's probably even easier for the parties. So if you all want to reach out to Mr. Lawrence in a day or 2 or 3, it sounds like that will work just fine.
Yeah, that works for me, Your Honor.
And if you see something on that needs to be reviewed, we can get you back on any Wednesday docket at 9 a.m. But I have Ms. Turnbull. I think we've got it covered. Matter. Okay. I think, and I'm looking at my notes, essentially we were on for review. Last time we were together, we needed to get the GAL fees paid, and Mr. Seraphin needed to return his intake packet. So maybe first I'll turn to Ms. Turnbull and see where we are.
I have received neither any fees nor the intake packet from Mr. Seraphin.
Right. Mr. Seraphin, I see you there logged in. What can you tell me about when we were together last? We talked about you getting your information back to Ms. Turnbull so the GAL can look into this case and get some recommendations to the parties and the court.
Okay. The paperwork, I've scanned it. I don't know if she received it. I scanned it and sent it out on email. So I don't know if she
I did not
received
receive anything. I did
Oh,
not.
yeah. Okay, I'll maybe I could take a screenshot of that.
Well, when did you do that?
I gotta go back to my email here.
Well, if you have it in your email, just go ahead and resend it. Make sure you have Ms. Turnbull's email correct.
It's on October 6th. I don't know. What? No, yeah, October 6th, wasn't it? Sent, yep. Sent it October 6th. I can resend it again. It's your email is let me see. A@gmail. Yes, that's what I sent to.
GAL as in guardian ad litem
Right.
at gmail.com.
Right. Yeah, I sent that on October 6th with the note saying any question, just give me a call. I'll send it again if you like. Here, let me see.
Yeah, so please do that, because when we were here on September 27, I think you were going to get that done. So go ahead and resend. Actually, sorry, that was November 1st. We did not
and I hadn't received it then.
Packet. So go ahead and get that sent over. And then where are you at, Mr. Seraphin, on your paying your fees?
I could come up with some money this week. It's been dead. I'm barely making rent too. So.
Hey, well, my hands are tied until parties, and particularly Mr. Seraphin, cooperate with the GAL. So all I can do today.
Is there a way I could go just drop the form off today?
I'll have to turn that over to Ms. Turnbull. I don't know if that's a possibility.
I will be in Kelso and Longview tomorrow. If you'd like,
okay.
I can meet up with you tomorrow.
Okay. What time you're thinking?
So let's do this, Mr. Seraphin. I don't want to take up court time scheduling this. So please reach out to Ms. Turnbull via phone and coordinate a time to either get those documents to her personally or emailed, okay? And then let's get payment made. I'm going to put a short review of this. You said you thought you could make payment this week. Is that right, Mr. Seraphin?
Yeah, this Friday.
Okay. So let's, Ms. Carroll, I know I don't want to take a ton of time out of your schedule, but I do want to set this on for a review next Wednesday at 9 a.m. just for payment, intake forms and payment from Mr. Seraphin. I won't be taking any action that day, except if we don't have the paperwork and fees. So Ms. Carroll, I don't know if does that work with your schedule to log on briefly at 9 a.m.?
Yeah, I'll make it work. I was just double checking. I got some kiddos wrestling now, so I just got their schedule yesterday.
Okay.
I'll make it work. It's just on Zoom, right?
Yep, just on Zoom.
Yeah, so next Wednesday at 9.
Okay. And we can call you near the top of the docket, because literally it's just going to be for me to ask Ms. Turnbull, did she get what she needs?
Okay. Thank you. I appreciate you taking the time this morning for me.
Yes, absolutely. So Mr. Seraphin, please get both of those things done before December 6th, and we'll see you all back at 9 a.m. Wednesday, December 6th. Ms. Turnbull, I also have you on this matter.
You do.
Let me just open that file here. Okay, so in this case, we were together last on October 25th. At that time, I signed a bench order for Mr. Bondurant to undergo a mental health evaluation to assist the GAL in her ultimate recommendations, but also this court. We did allow that to be concurrent with the same obligation in another family law case. I have not received any indication of whether that's been done. So I'll first turn to Ms. Turnbull, and then I'll come to Mr. Bondurant.
My understanding is that Mr. Bondurant has participated in the mental health evaluation. I have not received any results of that evaluation at this time.
Mr. Bondurant, what can you tell me about the status of that examination or report?
To this point, Your Honor, I took the intake. I literally got insurance and had an appointment made literally 2 hours after we got out of court that day.
Okay.
And that was provided to Amy Turnbull. I don't remember the exact date, but I did have the intake. It was shortly thereafter. I'm actually on my third or fourth appointment.
Okay.
So I've asked all the releases of information are there.
Okay.
And the person who has like full ability to read those is only Amy.
Right.
But there is releases of information for Chelsea also in regards to like appointments being made and stuff like that. Make sure there's follow through.
Okay. So that I'm glad that you added the release of information. That was going to be my next question, was whether you had signed that for Ms. Turnbull to receive copies. Does Ms. Turnbull have the name of the agency so she can request that if she needs to?
Yes, ma'am. And
Okay.
she also, I do believe, has the psychologist's information.
Okay.
I did, when I was at my last appointment, I asked if anybody had requested, and I don't know how it works. I'm not in that field, or I know that they are a little bit weary anytime people, they're very particular about how they release information because they want to make sure that it's completely correct because, they don't want to fall into a HIPAA violation of some kind.
Mm-hmm.
So they had somebody who's a lawyer there go through it with me and made sure it was all correct and that Amy would be provided all of the information that would be required by the courts. So, yeah.
Okay. Do we have review dates set on this one yet? Not past today. Okay. So let's set some review dates after Ms. Turnbull, so that gives Ms. Turnbull time to review the mental health evaluation and see where we go from here. So I want to set future dates here in a second. What I'll just say, and Ms. Bondurant, I'll hear from you in just a minute too, but I just wanted to put on the record, the court did receive a declaration affidavit of Ms. Bondurant dated November 22nd, 2023. And it's not noted on for any particular docket or action. And I don't see that it was served on Mr. Bondurant.
I did receive it, Your Honor.
You did or did not? I
did, Your Honor.
You
assuming
did.
Assuming that the unstamped version is sufficient and nothing's been changed or altered to the one that's been filed, yes, I did receive it. I also actually forwarded it to Amy as well.
That was going to be my next statement, was Ms. Bondurant, what it appears to me is that you do have some concerns about, who your child is being, your children are being exposed to. It's not noted on for any action for me today, and it wouldn't be timely anyway if you were asking for some action, because you have to give the other party 21 days notice if you're asking me to modify something. I didn't have proof of service either, but Mr. Bondurant is saying he did receive it, so I will find that he has been served with the document. I think probably more appropriately, it's a document that Ms. Turnbull will use in her ultimate recommendations to this court. But I'll ask you, are you asking the court for something specific today? But also knowing I really can't do anything with 7 days notice.
I was just I had talked to Amy Turnbull, and that was a recommendation that she had told me to do, was do a declaration and then get it turned in. That way, at least it was filed. And I had also emailed it to her from what she had told me to do, because the findings in it were, I wanted her to take into consideration, and then I guess in the court's consideration about who the kids were going to be around in such a short matter of time, when Mr. Bondurant's telling me one thing, and then, you know, now he's wanting to up and move with a girlfriend who he's literally saying that it's not like that with him and everything. So I just don't think it's appropriate that my kids would, I guess, possibly be around a girl who's been around 2 months, especially moving in.
I'm just looking at the temporary parenting plan that a judicial officer signed in this case.
May I respond, Your Honor?
Just a minute. I'll come to you in just a minute. Yeah, I'm not seeing anything that would address. Sometimes in parenting plans, there's language about that the court enters about children not to be exposed to a significant other until the relationship's been in existence for 6 months or more, those sorts of things. I don't.
Well, right now he has supervised visits, so nothing of that sort's in there.
Right. So I don't see that. So what I would say is I think you've done the right thing by giving it to Ms. Turnbull. Mr. Bondurant, I will come to you in a second, but I'm not making any rulings based on that declaration today. All I'm going to do today is set review dates so that we can keep investigating what is in the best interest of the children and move forward on this case. Mr. Bondurant, what did you want to let the court know?
I have a couple small things that I would just like to address to the court so it was on record. And I know that you obviously aren't going to rule on any of that today, but I want to make it noted areas of concern. Number one, I have communicated with Amy in regards to this concern also, like I said, so I just wanted to bring it to the courts. So number one, this relationship that I'm having has absolutely no bearing on this case on any level. It wasn't even introduced to Chelsea. It wasn't introduced to my children. And the only person that it was introduced to was Amy, which I would imagine would never have provided that information. It was well before that. So the declaration that I did receive, and again, I know that you're not going to overly extensively look at that. However, there are some majorly concerns in there in regards to what's there. It looks like people are stalking me. There's a protection order in this.
Okay, hold on. Yeah. So I'm not going to go too far down this road. I'm not making a ruling on it, so I'm not going to take up the court's time with speculation that you're being stalked or followed. If you think that you're being stalked, harassed, or followed, that's something that you can file a protection order for, or you can report to law enforcement. But I'm not going to take up time on this docket with that. What else do you need the court to know?
Okay, and then the other thing was I was under the impression that we were going to be at least attempting to make some additions to the temporary order that would provide at least the ability to have unsupervised visits if it was solely me. This is something that Mrs. Bondurant brought to my attention, and actually, in addition to that, brought it to my children, and they're kind of looking forward to. I mean, I'm 3.5 months into this, and I understand that this is a process, but I've undergone everything that the court's asked me to do. I've been very timely with it. I've showed up to every court date. I would really like to be able to see my children. And if by chance Amy or Chelsea may agree, I would like to see if there would be any possibility we could just make some small exceptions in terms of a couple of things. And another area would be that, like, online communication. My kids enjoy playing video games. They enjoy playing video games with their dad. It would be one area that I can still bond with them. And so that was kind of one area that I wanted to address today.
Okay. So I'll just I know you brought this up at our last hearing. I'm going to reiterate what I said at that time. Number one, so we've appointed a GAL. We've asked for a mental health evaluation. I'm not going to be making any changes until Ms. Turnbull sees that evaluation, sees what the recommendations are, and we have some input regarding unsupervised visitation. I will note that a judicial officer in this county signed the temporary parenting plan on September 7th, and it does include 3A mandatory limiting factors on you, Mr. Bondurant, regarding domestic violence and assault. So my hands are tied, essentially, until I have some reason to believe that those factors are not present. So I'm not making changes today. I understand your request. You've made it before. And I think my response before, as you've noted here today, is this is a process. It's kind of step by step. I need Ms. Turnbull to have that mental health evaluation. I need further input from her. If the parties want to file declarations with this court, Mr. Bondurant, about the steps that you are taking to overcome some of those limiting factors that this court took note of back in September, please feel free to do that. So what I wanted, so I'm denying your request today, but they are noted for the record. We are addressing them. We just need to get those professional evaluations back.
Would that include, that would obviously include making any minor adjustments that are already there in terms of the language on electronic communications?
What language are you proposing for electronic communications?
Like the one area that I know that I think Chelsea would agree that, I mean, still is regulated. I mean, it would be like the online for like video games and things of that nature. I mean, I don't see where that would be an additional risk there. That's my opinion. I can't obviously say that, but I can't imagine that Mrs. Bondurant would disagree with that.
Ms. Bondurant, what is your position on the children having gaming time with their father online?
That is probably their one area that they do bond on, is their gaming, and it's always been a good thing and a bad thing. They've really been wanting to be able to play with him because they run in the same crowd of gaming people, and so they have asked if they would be able to play with him. And
what is your position on that?
I mean, as long as, you know, he's not asking where mom's at, what mom's doing, I would be fine with it.
What I can do is enter a bench order that does allow gaming online with father. There will be specific language stating during gaming, no chat or discussions regarding the family law case, and no derogatory comments about mother.
And then I have one other issue, Your Honor, is I am just starting a new job on the 5th. I have to have uninterrupted, and I know this stings a little bit, but I have to have uninterrupted a month. December is all going to be training. And I know I brought this issue up in another court case with another child, and it was kind of went on deaf ears. On one hand, I'm being told that I need to get my stuff together. I need to get jobs. I need to get vehicles. I need to get housing in order for things to progress forward in this case. Mm-hmm. But I can't do that without some time. So I know that, like, obviously I would very much likely would like to get through this case as quickly as possible. But on the other hand, it's a double-edged sword. So I can't show up for any court cases in the month of December at all.
I don't see an issue with that because, I mean, you're the one who's asking for visitation to be expanded. So I'm happy to put our first review into January. Ms. Bondurant, do you have any issue with that?
Not at all.
Or, I don't mean our first review, our next review. Okay. That is not a problem, Mr. Bondurant. Good luck with the new position and the training.
Thank you, Your Honor.
Ms. Turnbull, what would be your proposal on, let's set 2 review dates, maybe something interim in mid to late January, and then I'm thinking February or March.
That sounds great.
Okay. Ms. Bondurant, Mr. Bondurant, it'll still be Wednesdays at 9 a.m. Anything that works better or worse for you? I think my first proposal would be January 24. So it'd be 2 months out, essentially. Does that work okay?
Yes, Your Honor.
That's the earliest one, Your Honor?
That would be the first review from today.
That's the earliest in January, though, Your Honor? I mean, that's almost 2 months away just for the, what do you mean by first review?
Mr. Bondurant, you asked for the entire month of December off.
I know, no. Was there another? Was there? Sorry, I apologize.
I'm proposing a date If you want a different date, just tell me what date you want. That's what I'm
Well, I was
asking.
hoping for early January. I don't know if the review is that what you're talking about, where we
Yep.
like.
Yeah, where hopefully Ms. Turnbull has received your mental health evaluation. She sees that you're still doing your treatment. Yes.
Okay.
We can bump it up to January 17. Ms. Turnbull, are you available January 17?
Yes, I am.
Okay. We'll do January 17 at 9 a.m. for the first, well, the next review, I should say.
Okay.
And then let's do end of February. We'll do February 28 at 9 a.m. Okay. And then if we need further reviews from there, we can. My hope is we'll have a pretty good sense of where we're going with this case by February.
Your Honor, so does that mean supervised visits are still, or?
Yes, the bench order, the temporary parenting plan, as amended by my bench order of October 25th is the mental health evaluation. So the September 7th temporary parenting plan with supervised visitation remains in effect.
Okay.
The only addition is a bench order I'm going to do today that clarifies that online gaming with father is allowed as long as there's no comments about the family law case or derogatory comments about yourself.
Would there be able to be a bench warrant that maybe just Mr. Bondurant's allowed to attend his son's sporting events? That's been a really big thing for my son as well.
Is he precluded right now from attending those?
I'm 1,000 feet, Your Honor.
Away from me, but I would be willing if he sits. I mean, it's a pretty big building. If he stays at one end, I'll stay. He knows where I sit. I always sit in the center.
So this is regarding a no contact order, domestic violence no contact order that you all have in a different case, correct?
Yes.
So you would need to, so I can't modify it on this docket with a family law order. I don't see any reason a court would not approve that modification, but one of you would need to file for our Monday civil protection order docket a request to modify to allow him to attend sporting events, even if he incidentally comes within 1,000 feet of you.
Okay, and then would he have to go to that? Because if I do it, he's not going to be able to obviously go because of his new job. Would he have to go, or is this just something that I can do and then I can just let him know through the app?
If you both want to submit, we don't usually do it this way, but I do protection order docket. So if you both want to submit an agreed modification order with agreed language on the sporting events and you both sign it, I have no problem doing that change off docket for the two of you, but I would need to see that both of you have signed it and submitted it directly to my attention. It's called, you would be filing it ex parte. So EX space PARTE to my attention. So if you both want to agree on that language and submit it, then we don't even need to hear it on docket. If you don't agree on the language, then yes, one of you needs to cite it on for a Monday protection order docket, and then both of you would need to be present.
Well, the only thing is on that is I would want it to be just Mr. Bondurant going. I don't feel like any other person would need to go.
So again, yeah. So again, well, I think what you need to be careful there is that the court under protection order doesn't have any jurisdiction over anyone else but the parties in the protection order. So I would not be able to preclude other people from being at a sporting event because it is a public event. But like I said, if you guys agree on language, submit it to me. I can get that done for you. If you don't agree on the language, then one of you needs to note it on for a Monday protection order modification hearing, and you both need to be present. And it is still on Zoom, so.
If one of us submits it and the language is to modify it, we both have to be present, is what you're saying, Your Honor?
Yes. If you don't agree on the language, if you don't submit an agreed modification order, then if you don't agree on the language, it's got to come up on a Monday, 9 a.m. protection order docket hearing.
Okay.
Okay. And then the court would make a decision about what the language should be. Okay. Any other questions for me?
I don't believe so, Your Honor.
Okay. So we have you back January 17, February 28. Ms. Turnbull does now know that the ROIs have been signed with mental health. So that's good. I'll do the bench order for the gaming authorization, and then you all have some information if you want to amend the protection order. Anything else?
Your Honor, I do have one more question.
Yes.
Mr. Bonner had expressed some concern when the mental health evaluation comes out about how that information gets disseminated and who has the ability to access that information and then where that information might go. You know, typically both parties would get a copy of that. And I know the other case that may be the case, you know, that may happen as well. You know, can we have some sort of agreement ahead of time about how you would like me to handle that information given his concerns?
Yeah, so Mr. Bondurant, is your concern that you don't want Ms. Bondurant to have the mental health evaluation physically, or you tell me what your concern?
I think I 100% endorse mental health, and I know that I've neglected it over the years. However, I'm willing to do everything that I need to do for myself. However, a part of that is taking into consideration the fact that I was audibly concerned to Amy initially when I was signing the ROIs, because there wasn't a specific language by the court as to what needed to be presented. I just knew that ROIs needed to be released to individuals. And I don't trust that my information is going to find its way onto social media platforms, that it's going to find its way to other people to arm themselves in other ways. And that's concerning to me. And really realistically, it makes me feel like I can't be comfortable with the person that I'm speaking with. And like I said, I've been completely transparent with my counselor in kind of good faith that the information would end up being released, you know, in a way that was protective to me, but also maintained the relevant information that needed to be provided for the courts and Amy. But like the things that I don't believe need to be necessary are what the diagnosis is, unless it pertains to child at risk. As long as Amy knows and knows what we need to do to, you know, mediate around that situation, or he needs to continue counseling or medications that he needs to be taking. You know, I have no problem releasing information on medication or treatment dates or making sure that I'm still attending. But I don't think that like literature inside of that would be necessary to have for anybody other than a counselor and the relevant people.
So I think what I can tell you on this is that anything that's filed with the court for review is filed what's called under seal, meaning it doesn't become a public record. So if someone were to request anything from this case, that your mental health evaluations don't become part of that. So,
but if there's a release of information to Chelsea, sorry.
Yeah, let me finish. So I understand your concern to some degree. I think some of it might be, you might be hypersensitive to some of this. I don't know how realistic some of your concerns are, but I hear you. And the best I can tell you is when it is filed with the court, it is under seal. Ms. Turnbull only releases her report under seal. So in discussion of specific mental health diagnoses, that is also kept under seal with this court. So I'm not quite sure how to fully address your concerns while also.
So that release of information is very specific to Chelsea.
Sure. You keep interrupting me. Just wait, please. I I also just need you to know that the court has to have this information to decide what is healthy and safe for your children, given that there are 3A and 3B limiting factors that a judge has found. So we do need your diagnosis. We need your treatment plan. We need to know if your counselors think that there's a safety concern for the children. And the parent, the other parent in this process, is entitled to know that too, so that they can advocate for best interest of the children. Now, I can tell Ms. Bondurant, you know, absolutely under no circumstances would the court condone redisclosure of any medical information, especially mental health, that you receive of Mr. Bondurant's. I haven't seen that be an issue in this case yet, but I'm happy to say that on the record to Ms. Bondurant, so that she knows the court does take your health privacy very seriously. Beyond that, I'm not sure what else you're asking for.
I'm concerned. I'm not concerned on the diagnosis. I'm concerned on what is personal stuff that I share. Basically, if I give full access, a release of information that gives full access to details to what is talked about, that's not a diagnosis. So I need very specific. I don't think that if for somebody like Amy to sit here and go through the documentation and say, okay, this is relevant, this is irrelevant, this is, so on and so forth. But, hypothetically, if there's a sexual assault in my past that I don't want to be presented to her in a legal document that she can, whatever, I don't think that that's something that I need to release to her. The diagnosis, yes. And in that, like, I'd imagine in those reports, right, by the guardian ad litem, it's going to be sensitive to that and obviously put into a report eloquently. But there's a lot of childhood trauma there that I don't need to be on paper. That I don't need there to be like the summaries of it or what I'm communicating about or things of that nature, unless it's relevant to the diagnosis. It's not very specific. It just says release of information. I mean, to the psychologist, that sounds like to him that anything that she asks, he has to provide. It's not specific.
Well, again, you are right. I mean, that is what the court is requesting as part of a full mental health psychological evaluation. And again, what I can tell you is we file those under seal. Ms. Turnbull files her reports under seal, so it doesn't become public information. But I think that's the best I can tell you. I'm not going to make a ruling that tells a mental health professional what can and can't be shared from your sessions. I think that's far outside my scope.
I mean, I understand it being shared with the courts and Amy Turnbull. I don't understand why it's parent specific.
Okay. Well, you have my ruling. I'm not
okay.
doing any limiting factors on what is in the reports. Beyond that, is there anything else we need to do today?
No, Your Honor.
Ms. Bondurant, anything?
No, Your Honor.
Okay. All right. We'll see you back on January 17th unless one of you has an issue and notes this back in sooner. Okay.
Thank you, Your Honor.
All right. Thank you all. You're free to log out.
Perfect.
Thank you.
Thank you.